the Supreme Court is considering what's possibly the most controversial case of the term. On Wednesday, the justices heard arguments for Moore v. Harper, or the independent state legislature theory. Simply put, a group of Republican lawmakers are arguing that state legislatures should have nearly unlimited power over elections. The decision won't come for several months, but if this court agrees with the Republicans, it could have drastic consequences for every election in the future. Back with us, Melissa Murray, professor at NYU School of Law and an MSNBC legal analyst. Melissa, on this case about Moore v. Harper, the New York Times editorial board had this to say about it. To be clear, this is a political power grab in the guise of a legal theory. The theory has no basis in law, history, or precedent. The idea that state lawmakers exist free of any constraints imposed by their constitution and state courts makes a mockery of the separation of powers, which is foundational to the American system of government. Melissa, do you agree?
I think that says it all, Jonathan. I mean, to call this independent state legislature theory a theory is really to strain credulity. It's really more like fan fiction, and the fans who really love it are conservative legislatures who use the independent state legislature fan fiction / theory to further consolidate their authority. This case, Moore versus Harper, began with a partisan gerrymander that the North Carolina Supreme Court struck down because it violated the state constitutional provision requiring free and fair elections. The legislature then countered and filed this suit, arguing that the state court has no authority to interpret North Carolina's state constitution to provide for free and fair elections for North Carolina residents. The idea that the legislature, which is a creature of the state constitution, which is created by the state constitution, isn't bound by the state constitution is absolutely ludicrous.
Incredible. Let's talk about another case. This one is about a Colorado web designer who refuses to work on same-sex weddings. Do you have a sense about which direction the justices are leaning in that case? Because this is a case where it's all about hypotheticals.
Well, I mean, that tells you everything you want to know, Jonathan. Federal courts, including the Supreme Court, are courts of limited jurisdiction. They're limited to hearing cases where there is an actual case or controversy. Here, Lori Smith, the website designer, hasn't actually tried to create a website for same-sex couples.
Right.
No same-sex couple has approached her. This is a purely hypothetical situation, but the fact that the court has agreed to hear it and entertained it suggests how eager they are to get to the merits of this case, the underlying merits. And as you say, this was an oral argument completely filled with outlandish hypotheticals, from Black Santa to AshleyMadison.com, a website for those who are prospective adulterers. It was absolutely wild. What was absolutely missing from this oral argument were actual real people who were injured here, like same-sex couples who would be denied services in the public sphere. They were absolutely, utterly missing from this oral argument because, again, they haven't actually approached this woman for services. This is a purely hypothetical question, and it seems like the court is eager to vindicate the interests of this website designer. I counted at least 5 votes, possibly 6 for Lori Smith.
Well, all I know is that at this point, that Colorado web designer doesn't have to worry about same-sex people coming to her for any kind of services. One more, the next case, President Biden's student loan plan. The Supreme Court agreed to hear arguments about the program. But I'm wondering if you saw Jamelle Bouie's column in the New York Times today, where the headline is the Supreme Court is turning into a court of first resort. And he talks about how the court, you tell me, you're the lawyer here. Shouldn't someone have sued in a lower court and have it bubble its way up to the Supreme Court? This seems to be the inverse.
I mean, this is the complaint that many have been making about these emergency relief cases that have gone to the Supreme Court. Like, we're completely bypassing the whole process of developing a factual record on the ground, of having this percolate through the federal courts and then on to the Supreme Court. And that's consistent with the idea that whatever we can't do through ordinary majoritarian politics, we will instead do through the courts themselves. So again, here, the student loan provisions, the Biden administration has done something where there's a fair amount of public support support for this. People think that something has to be done. Congress is too polarized to actually do something about it. The executive took the lead on this. And those who object, rather than, again, dealing with the executive, dealing with Congress, instead have gone to the courts to try and deal with this, and specifically to the Supreme Court. So again, here we are.